Okay, so a little bit about myself. I'm not a lawyer, so this isn't legal advice. I have a law degree, and like you all, I have a general interest in law and have for a long time. In this video, I intend to look at human rights in the UK, how they've changed, what they are, and why they are. So I guess the first question really is, why are the human rights important at all? Why would you be even vaguely interested in knowing anything about them? And I guess it comes down to a general interest. Most people who are watching this will have at least some interest in law and the reasons why laws exist. As I have, I've often felt that a broad understanding of the way laws operate in the UK is something that everyone should know, and something that all citizens should take an interest in, because it fundamentally affects the way we live our lives and the system of laws that we live under. The Human Rights Act is no exception to that. It may not affect on a day-to-day level the way people live in the UK, but it does affect the way we think about laws and the way laws are applied fundamentally. It's part of a broader background fabric of the legal system, which day to day you just don't see in operation, but is very much in effect throughout the UK and is very much affecting your lives, even when people don't necessarily realise it is. Now, maybe you don't have an interest in law like I do, or at least as broad an interest in law, but maybe you're considering doing law at some level and at some point. Now, this is not in any way a substitute for actual teaching and learning under a law degree or a college course or even an open university course. I don't pretend that it is, but I think I can give you at least some broad brushstrokes and perhaps an interesting look at least some of the things that I, whilst doing the law course, have found to be interesting. Another aspect as to why the human rights and knowing about human rights in the UK is important is because recently we found those rights potentially threatened, and threatened in a way that I feel, to be honest, a large amount of the populace didn't really understand that they were threatened and what that would have meant for them if it had come to pass that those rights had been removed. Only last year, the Conservative government proposed changes to the UK laws that would have fundamentally altered the Human Rights Act in a way that would have removed the rights that we enjoy under that act. They did so to facilitate their political aims, and they did so at the time without fundamental, widespread opposition to that plan. And part of the reason that I think there wasn't that opposition is not that their plan would not have affected people in the UK, but instead it's because, or at least I feel it's because, the vast majority of people in the UK don't really understand what the Human Rights Act is and what it does for them. So no one really felt that they were threatened by this. Others might be, but they didn't even know that. And I think that's a massive problem. So if I can in some way inform people and change that, I think that is a fundamentally worthwhile thing to do. So I hope you kind of understand the importance of the Human Rights Act and will kind of bear with me a bit, because I think the best way to understand the Human Rights Act is actually to step back, not just one pace, but several paces, to go back to not the formation of the Human Rights Act itself, nor the convention rights, but actually all the way back to 1215, which is the creation of the Magna Carta. Now, the Magna Carta doesn't have that much impact on the modern legal system, at least not in the form that it was initially created in, but it has as a building block, a stepping stone to further reforms. And the Magna Carta is a document which essentially stripped some of the powers of the monarchy and gave them to the barons, and created the first concept in the UK of the king ruling with something like a parliament to control their powers and to moderate the way a king rules. Magna Carta was considered so heretical at the time it was created that it created two countrywide wars, the First and Second Barons' War. And it's only after the first time we actually had someone in charge of the country who wasn't a king, in Henry de Montfort, that we actually had an agreement from the monarchy to rule with Magna Carta and with the help of the barons. So as you can see, it's kind of a crucial stepping stone from an all-out monarchy with one monarch who controls every single law in the country, every judicial system, every method of creating laws, all the power in one person. And it's a stepping stone to the way we operate today, with most of the power delegated from the monarch to the parliament. And as that crucial stepping stone, it establishes some rights and some powers that Parliament, or at the time, the barons, possessed. Now, I'm not going to go into every single separate piece of legislation that came after the Magna Carta that slowly ate away the power of the monarchy and delegated it to Parliament and to the people, because it's a long, long road and a lot of history and a lot of wars and rebellions and acts. But I am going to touch on one other crucial piece of legislation, and that's the Bill of Rights, created in 1988. Because that is the most up-to-date version of it. And basically, that is our current codification of the rights of Parliament, the rights of the King, the rights of the people, and it limits how those rights are utilised by any of those separate organisations. So it limits what power the monarchy has over Parliament and the courts, and what powers are still retained by the monarchy and not by Parliament and the courts. The Bill of Rights has been around for a long time, and it does occasionally get updated, and new sections are created and removed as we go along. But most of the time, the legislation is quite set in stone and hasn't exactly moved. So now we kind of have the basics of the legislation out the way, the early stages, how this was created, the early stages, why Parliament operates as it does, and how the monarchy operates and why it does as it does. I think it's important to look at the roles of the court and Parliament and the monarchy. So, Parliament's role is to control the rights and regulations of the people, to adapt those, to discuss them, to change them, to legislate for those. And the monarchy, for the most part, stays out of that process. Now, there is some intermeddling with that, and sometimes that is not quite the case, but for the most part, the monarchy stays out. They rubber stamp the laws that Parliament, in both of its houses, the House of Lords and the House of Commons, legislate for. The court's role in that is to interpret the laws that Parliament creates, that the monarchy rubber stamps. It's courts that see those loopholes and fix them, that interpret how the laws were intended to be conceived of and intended to operate. And where there's ambiguity, that's where the courts operate in. They operate in the ambiguity and either increase that ambiguity or decrease that ambiguity, depending on how they think the law was supposed to operate, or the intentions or the ways in which they think the law should operate. Now, it's really, I think, a question for another day, something to bear in mind, but come back to, really, and maybe the topic of another video. But there is such a thing as the separation of powers. So this basically means that no one person can be both the judicial and the legislative. The monarch cannot be all of these. The Prime Minister cannot be all of these. It helps separate out these powers and responsibilities and the rights that these offices hold and the way that these offices operate. It provides a series of checks and balances that try to make sure that a dictator cannot take over the whole system, that one branch of the system cannot overpower another branch of the system, and that no one particular piece, like the legislative for instance, cannot trump over the courts, that no single piece can hold more power over another piece, such as the legislative cannot have more power to operate than the courts. While this is a fundamental principle, it kind of works amongst the background of all of this, but it's vital when considering Parliament and the way laws are created to remember that separation of powers exists and why it exists. But like I say, it's probably a topic for another video. So I want to finally, and it really is finally, I suspect, move on to the Human Rights Act itself, and then I'll jump back, much as I did in the first section, to the start of human rights and how that was created and the history behind that. So, I guess the key question with the Human Rights Act 1998 is, what exactly does it do? And it codifies the convention rights and protects those rights in British law. So it creates a domestic route whereby if an individual feels that their human rights have been threatened or indeed harmed in some manner, they can have a method where they can seek redress for that. Now, it's important to remember that it isn't the convention rights. They are quite different, and the Human Rights Act 1998 does not codify every single right that the convention has. It codifies the majority. One of the key reasons that Parliament created the Human Rights Act in the first place is a thing that we'll touch on most likely in another video, because I do think it's a topic that would take too long to explain now. But in brief, it's parliamentary supremacy and the sovereignty of British laws. And the reason that Parliament decided to do this was partially to have their own way, so that another country wasn't dictating the laws of this country, and also that Parliament is the only institution that can create new laws, or at least has the power to create new laws. So, looking back at the convention's history, so this is the European Convention on Human Rights, and this happened on the 4th of November 1950, and it happened in Rome. And it's a big meeting where lots of different countries came together to sign a convention on what they felt were the rights innate to a human. The signed convention came into effect in 1953, but because it's signed in 1950, we consider it to have occurred in 1950. So some of the background that started people on the path to creating a convention of human rights that codifies what rights we should all possess. Really, it's the backdrop of World War II and the trials at Nuremberg of war criminals, and those war criminals and the abuses of innate rights which had never truly been questioned before World War II, really started people on the path to thinking we should have some method by which we all agree on what kind of rights people possess, so that we can better know when those rights are being impinged and impeded, and we can start to consider when people might be going too far before they've gone the full hog, the full way to totally stripping a whole group of people of their rights. And the way that they began to do this was through the convention and through the rights everyone decided should be human rights innate to everybody, and the institutions that were put in place by the convention. And the concept and the idea that every signatory to the convention agreed to give their people, the entire populace of their countries, these rights, and to abide by them and to hold people accountable when those rights were broken. One of the key methods in allowing them to actually hold people accountable was to set up a mechanism to rule on cases. And the whole procedure of a convention was conceived of that every member of the convention would hold each other accountable, so that no one country could totally abuse their own population's rights because of the political pressure that would be put on that country from all the other signatories. Now, it's arguable whether that has ever truly worked in practice and whether it was the best way of doing it, and there've been times where it's worked and there've been times where really it hasn't worked as well as it should have, and there've been other methods, much like the Human Rights Act, to try and codify that and to create methods within the countries themselves that people could be prosecuted for abuses of those rights. Because you've got to remember that the convention itself didn't create a mechanism to hold individuals accountable, merely nations, countries on that scale. Whereas stuff like the Human Rights Act, it helps to create a mechanism within UK law where an individual can be held accountable for breaches of those rights. So the convention isn't anything like the Human Rights Act. It's a totally different thing, but the two do work in tandem in the United Kingdom. I think that kind of ends it for today, and this video. Next time we'll be looking at the European Court of Human Rights and the procedures which hold people accountable and countries accountable to the human rights that the convention agreed upon. Thanks for listening, and if you are listening on YouTube, subscribe and like this video. For more from this channel, make sure to click that notification bell. And if you're listening on Spotify, please follow this podcast, and again, click that notification bell. Whichever way you've been listening, All comments are greatly appreciated, so if you have one, please leave it in the designated comments area.